Hey, what's up guys? Today we're going to talk about the differences between guarantees and indemnities. Now, guarantees and indemnities are a common way in which creditors, that means lenders, protect themselves from the risk of bad debt. That means people who borrow money don't pay the money. Lenders will often seek or ask for a guarantee and indemnity in the loan documents if they have doubts about the borrower's ability to pay back the loan. Let's talk about guarantees first. What is a guarantee? A guarantee is a contractual promise by a person to ensure that a third party, someone else, fulfills his obligations and pay an amount owed by the third party if he fails to do so himself. So for example, A borrows money from a bank. I am the guarantor. In other words, I'm giving the bank a contractual promise to ensure that A would pay back the loan to the bank. A guarantee is a secondary obligation. That means ranking below the primary obligation of the borrower, because it's contingent upon the obligation of the third party known as the principal to the beneficiary of the guarantee. That's why most guarantees states that it's a primary obligation. In other words, A borrows money from bank, okay? That he has a primary obligation to return the money to the bank. I am the guarantor. I'm giving a promise to the bank that if A does, I'm giving a promise to the bank that A will fulfill his obligations under the loan agreement to pay back the bank. If A does not pay, then I am required to pay. So I am a secondary obligation. So this is a guarantee law, that the guarantor's obligations are secondary to the borrower whose obligation is primary. That's why in a lot of guarantees, they try to change this by stating that the obligations of the guarantor are primary. So they don't want the guarantor's obligations to be subordinated to that of the third party A. Now we're going to talk about indemnities. What is an indemnity? An indemnity is a contractual promise to accept liability for someone else's loss. It is a primary obligation because it is independent of the obligation of a third party to the beneficiary of the indemnity under which the loss arose. To use the previous example, A borrowed money from bank. I am the guarantor. So in the case of an indemnity, the indemnity itself imposes on me a primary obligation that if the bank suffers any loss, I have to compensate them, the bank, for its loss. It is in a sense wider than a guarantee because if the bank loses money, more money than the amount that they loan, for example, if the bank lends $1 million to A, okay, as a guarantor, I have to guarantee the $1 million. If A does not pay the $1 million, I have to pay. If I had given an indemnity to the bank in addition to a guarantee, then it will be wider because the indemnity will compensate the bank for all its losses incurred. So for example, if the bank sues the borrower, I have to pay all the lawyer's fees and any other fees or losses that the bank will incur. So it may be even more than 1 million. So that's the purpose of an indemnity. What are the advantages of an indemnity? Unlike a guarantee, an indemnity does not have to be in writing or signed by the indemnifier. This is under Section 4 of the Civil Law Act. And since it is a primary obligation, an indemnity will be valid even if the underlying transaction is set aside. So if for some reason the loan documents between A, the borrower, and the bank are void or set aside for some other reason, unlike a guarantee which extinguishes, is cancelled, which is guarantee is depending on the underlying transaction. An indemnity, on the other hand, will remain valid even if the underlying transaction is set aside. Furthermore, if there's any variation, that means changes to the underlying transaction, it will discharge the liability of a guarantor, but not the liability of someone who gives an indemnity. okay, unless unless the guarantor consents to the variation. But in the case of indemnifier, if there's any change in the underlying transaction, he will not be discharged, and he doesn't have to have his consent to be for any change in the underlying transaction. Because of the issue of consideration, which is essentially giving something of value in return for a promise, you can watch the video I made on consideration below. Because of the consideration issues, guarantees and indemnities are often executed as deeds, okay, instead of contracts, to overcome any arguments later in time during a lawsuit about whether good consideration has been given. Using the last example of A borrowing money from the bank and getting me to guarantee his obligation, even though I give a promise to the bank to guarantee the repayment, the bank doesn't give me anything in return for my promise. So there's an issue of consideration. I give the bank a promise, the bank does not give me any promise. So to overcome this, the guarantee and indemnity will be issued as a deed, D-E-E-D, which does not require consideration. So thanks for watching this video on the differences between guarantees and indemnities.